have access to it just in case you should miss it. So thank you very much for being here this morning. My name is Teresa Shaver. I'm the CEO of the Business Advisory Center Durham, and along with my colleague Marlon Shaw from the BACD. Give us a wave, Marlon. We're happy to have you here this morning, and we look really forward to welcoming our legal eagles who are going to help you understand a little bit more about their areas of specialty, and really it's legal information around your business. So we're going to start this morning with Michael Hunter from Koziar, Reczulski Hunter, who's going to talk about incorporation and different parts of that. So if you have questions, it's also a good idea to put them in the chat box. Because we are moving pretty fast, it's really going to be high-level information, and then your opportunity is to connect directly with
Dear God, my camera just turned on.
Well, and we heard that.
Sorry about that, everyone.
That's okay. That's okay. Please mute yourself, everyone, if you can. It happens. Thank you very much. Good morning. Good morning. Okay, so I'm going to start with Michael Hunter from Koziar, Reczulski Hunter, as I just mentioned. So Michael, you have shares screening, and we'll get started. Thank you very much.
Good morning, everybody. Sorry for that rocky start. It's been a while since I've had to control and share on a Zoom screen. So happy to be here and presenting. As Teresa said, I'm from Koziar Reczulski Hunter Law. I'm a partner here. We operate in downtown Oshawa and do a variety of practice work. So corporate commercials certainly up there in my practice. Also do both commercial, residential, real estate transactions, some family law, wills and estates. So a variety of practice areas here. So we're going to talk today. My role has been to give you the high level overview of the corporation. So what is involved? I can show you here the roadmap. So we're going to do the pros and cons to start off with, because I think that's what everyone wants to know is what are the benefits to having a corporation and what are some of the cons? And second, we'll be looking at getting started. What do I need to know to get started with a corporation? What are the decisions that I'm going to have to make? Some of the liability questions. So one of the big pros of the corporations is your limited liability. So we'll talk a little bit about more about that. The financials of a corporation, some of the flexibility that a corporation can give you, the costs, and then we'll open it up for some questions and answers. So one of the big things to know is that every situation, every business is unique. So while I'm presenting you with some high level information here, it's really important if you are considering whether to incorporate yourself, that you do seek some advice from a legal professional. Because again, you might get something from this presentation and there may be something unique about your business that would lead you down a different path, or that would be a better road for you. So keep that in mind. But hopefully we'll be able to share some good information for you. And please fill the chat with questions. I'm not going to answer them until the end, but I will stop a little early so that we can have a little bit of a chat and discussion for any questions you have. Don't be offended if I can't answer some very specific questions. Please ask them anyways, but I'm not able to provide any legal advice in this presentation. It's reserved for when we've actually built a solicitor and client relationship, but I'll do my best to answer any questions that do come up. So the pros and cons. First off, we've got the pros. So there's a lot of financial advantages that you can have to a corporation, and we're going to talk about each of these in a little bit more detail, but I just want to give you the high level overview of the pros and cons. So there's some financial incentives. Your limited liability is a big one. A lot of people will incorporate primarily with this motivation in mind. Corporation is a separate entity from yourself rather than a sole proprietorship. So there's some very good advantage to that separated liability. And there's a lot more flexibility and ability to get creative over how you're dividing the ownership of a corporation and how you continue it. Some of the cons is double taxation. With some careful tax planning, this can be avoided or greatly reduced, but there's always that risk that you'll end up paying more tax than you otherwise would have. There's a lot of startup costs to getting the corporation up and running. And then there's the continuing costs. It's both a time expense because there's additional reporting requirements that you are going to have, but you're also going to have potentially increased accounting costs and legal costs as well if you're having a lawyer or some other legal professional managing your minute book. And then, as I said, you've got ongoing reporting and record keeping, which is, as busy business owners, one more thing to do and stay on top of is difficult. So you've got to really think about whether that's going to be worth the expense. So getting started in your corporation. The first thing you've got to think about is whether or not to incorporate. So you have to, first off, seek advice from a lawyer and an accountant, especially. A lot of people might be considering the tax advantages. So you really need that advice from your accountant. But you also got to consider, and your lawyer or accountant can help you consider this, alternate business structures. So you might think, well, it's really just a sole proprietorship or a corporation. Those are the two ways of doing business. But you can form a partnership. You can have a joint venture. There are different means of potentially achieving the goals that you want to have that you don't necessarily have to incorporate for. So you want to think about what are the different types of business structures out there and what makes the most sense for me. So if you've decided that you do want to incorporate, then there's going to be some decisions that you have to make. So the first thing to think about is, do you want to have a name for your corporation, or the default is that the government will just assign you a corporate number. So 1, 2, 3, 4, 5, 6, 7, 8 Ontario Inc. And that could be your corporate name. What's really important to keep in mind here is you have an obligation as an incorporation, or the corporation, I should say, has an obligation to do business with its legal name. So if you don't go with a named corporation, you have to always include that number somewhere. So you can register a business name later on, but you would always have to, in all your contracts and all your advertising, name yourself as, Mike the lawyer operating as 1, 2, 3, 4, 5, 6, 7, 8 Ontario Inc. So that can get clunky in your contracts and not look as nice. Normally, if you're operating a business that's providing a service or selling goods directly, and your branding and your name has value, you would want to see if you can get that name as the official name of your corporation. And there's some rules around that as well. So if you haven't already registered your business name, you're going to have to do, or either way, you'll have to do what's called a nuance search. So you'll have to have a full search done of all the registered names in the province and potentially across the country as well. And you're going to need to make sure that your business name is sufficiently unique so that you're not going to be liable for passing off as operating as somebody else's business. So you can't, if it's Michael's Cakes and Cookies and I'm operating in Oshawa and there's a Michael's Cakes and Cookies in Toronto, we might have some problems there. And certainly the business that was already established is probably not going to be too happy that you are registering with the same name as them. So there's some searching and some planning around that. I usually tell people to, if it's going to be a somewhat common name, to give me 3 different iterations. So you want to think about different names that you could have and how you're going to register that. The next you got to think about is your office address. So there's certain information that is publicly accessible when you register a corporation, and the office address is one of them. So for a lot of people, they operate their business when they're just getting started out of their home. Is that going to be your office address? Is that where you're operating the business out of? And keeping in mind that will be information that anyone can access if they're doing a search of your corporation. And then the big one, you've got to pick out who are going to be the directors and officers of your corporation. So this is going to be, wide-ranging and dynamic. You don't set a director and never change that throughout the life of the corporation. But when you're getting started, you got to think about who are going to be the key decision makers in this corporation. For a lot of people I work with, it's one person. They're they wear all of the hats in the business. So they're the director, they're the officer, president, secretary, chief marketing officer. They're doing everything. So that's it for a lot of people when they're getting started. But if you're going to have multiple people, if you're starting a business with 4 or 5 people, let's say, and it's a partnership situation, then you got to think about who the directors are going to be and who the officers are going to be. So the directors have more the high level control of the corporation. The directors have to do important work in guiding the corporation and making sure the corporation's staying on the right legal track. So they've got to select and approve the accountant. They can require or waive the requirement for an audit. They can decide when dividends are going to be issued, to whom and how much. So who's going to get paid out of the corporation, and a number of different items. So this is one item, your director, whose information is going to be publicly accessible again. So if you're thinking about the director of the corporation, that person's name and contact information and address is going to be part of the public record when you're searching that. And anytime a director changes, if they leave or if a new director is added, then you have to register a form and update the government about that. Your officers should be registered as well with the corporation. And generally, this is what you would think of as the people running the day-to-day of the corporation. So the president, vice president, you can name, the title doesn't matter. You can essentially name whatever officer position you want. And generally, these will be people who have signing authority or may have signing authority at the bank. And again, that's running the day-to-day operation. So the officers and the directors can be the same, or they can be different. The director is more of the high-level meeting, maybe only once a year or maybe a couple of times a year to approve certain strategic positions of the corporation and the operations, whereas the officers are more the people actually doing the day-to-day work in the corporation. And again, for most people, they're one and the same. They wear all hats, but something to consider as the business grows. You've also got to think about whether you're going to register federally or provincially. So if you're going to do business strictly in Ontario, then you would say, well, I'm going to register here under the Ontario Business Corporations Act. However, if you're thinking that you're going to do business in several different provinces or branch out and have business locations and provide active business services across the country, then you may need to register federally. And doing so, for one, it allows you to operate in any province without additional registration requirements and approvals, but it also protects your name. If you're registering a name, you want to register that federally. It gives you some protection around that as well. So that's a consideration you'd have to think about where you're going to be doing business and how to register. And then you want to think about, and you can do a shareholder agreement at any time, but if you're registering again with a group of people, 3 or 4 different people perhaps, or even 2 people at arm's length from each other that are entering into a corporation who are both going to be shareholders, you would want to make, definitely it would be advisable to get a shareholders agreement in place. And this is going to lay out the terms of, it can essentially lay out anything, but it's the relationship between the shareholders, essentially. The shareholders being the actual owners of the corporation. So when you can sell your shares, who you can sell your shares to, if there's going to be a shotgun provision where someone can force a buyout, what happens upon one of the death of the shareholder, and all of those kind of interrelational agreements, making sure that a shareholder doesn't go insolvent and protecting the shares against being taken over by individual third parties. So that's the before incorporating, and then you're looking at after incorporation. So what's required going forward? So you've got your minute book, and you may have heard this term before. The minute book is your record of the corporation. So every corporation has to keep a minute book and has to keep it up to date. And what's required in your minute book is your listing of all shareholders. So that's not put on public record, but it is required to be kept in this book, which can be accessed upon request by the public. So you've got that. You need to include who the directors are, whether an auditor has been appointed and who that is, who the bank is, any property the corporation owns, any dividends that are given out. So it's essentially telling the story of the corporation is how I often describe it. And the minute book keeps that story up to date. And so we're just doing a high level, but you've got to know that there's strict requirements in the different legislations, the Ontario Business Corporations Act and the Canada Business Corporations Act, about what's required in the minute book and how often that has to be kept up to date, and what you need to do to stay in compliance with the legislation. We've also are going to be getting in touch with CRA. When you incorporate, you're going to get a corporate tax number. If you have employees, you of course have to have your employee number, potentially HST number, and set that up, because the corporation is its own entity and it has its separate reporting and taxation requirements. And you got to set up a corporate bank account. So you got to go to the bank and get that set up. So that is the overview of how to get the corporation kind of going and set up. I'm just looking at my time here. I think we're doing okay. And now we're going to take a little bit more of a deeper dive into the pros and cons. So the liability, again, a lot of people will take a corporation on to give themselves a little bit of a shield from liability. And really, I think as best I can give some examples of this. So if you are running as a sole proprietorship, so you don't have a corporation, you're doing business without any formal structure. So even if you have a registered business name, if you're not incorporated and you're running as a sole proprietor, if your business gets sued, then you are being sued personally, which means your house, all of your assets are really up for grabs as far as what's at risk in terms of your liability, and what assets are at play if there's a judgment made against you, and the judgment, the successful claimant is seeking to enforce that judgment against you. So many people will come to me, and one of their big concerns is the house, right? You don't want to be doing business, something happens, insurance is not covering it, you're personally liable now for a large amount of money, and you're nervous that your house is at risk. If you have kids and things like that, you want to really protect that asset particularly. You don't necessarily have to incorporate to do that. You can, there's different ways around the ownership of the home that can be looked at, but one of the big things, or one of the things that you can do, is incorporate. And it's important to know that, again, the corporation, what I always tell everyone, it's a separate person. It's a legal person under the act. So you are not the corporation. You might be the shareholder in that corporation, but just as if you owned shares in Coca-Cola, if Coca-Cola got sued, you wouldn't be expecting somebody to come and tell you that you owe them money because they have a debt against Coca-Cola. So it's a separate entity, it's a separate structure, and it exists separate from yourself. So a corporation can sue and be sued and has many of the same rights as an individual person. Corporations can't.
Google pause.
There's restrictions on that, but essentially under the eyes of the law, they are a legal person. But saying that, you're not completely free from liability. So particularly the directors have an important role in the corporation. And one of the big things to know about is what's called piercing the corporate veil. So if somebody does sue you and they've said, well, you've actually incorporated for a fraudulent purpose, just to shield yourself from debts, and there's no genuine reason for you to have made this corporation other than to defraud the public at large, or to defraud whoever it is that's suing you. Or if you're, as a director, directing the corporation to commit fraudulent acts, or other perhaps criminal acts, you can't hide behind the corporation to commit crimes. It's, I think, the highest level way that you could say that. If you do that, then you would still be personally liable. So it's not an absolute shield, but in your day-to-day business operations, when you are, acting honestly and not fraudulently, then it acts as quite a good shield from liability, from personal liability against you. That being said, all the assets of the corporation are still going to be at risk. But that's one of the biggest things, is to limit that liability. Now, the financial benefits. So with your corporation, many corporations, it depends on what industry you're in, and the size of your corporation, but you're going to be taxed at a lower rate than acting as a sole proprietor when you're taxed, everything's just taxed as income. So money that's kept in the corporation may be reinvested in the business and used, even some people will use it for a little bit of a retirement fund to keep money in the corporation, because it will be shielded from tax at a lower rate. When you take that money out of the corporation, the CRA is going to get their fair share through dividend taxation. However, some people will save that until later on when their income is lower, and you can kind of structure and strategize around taxes to kind of get that lessened. And it's also can free up some ability to invest in the business with that income that's after tax income that's paid through the corporation at a lower rate. The next big one is, future planning. So there's a lifetime capital gain exemption in Canada. And if you are a Canadian controlled private corporation and you sell your shares in that Canadian controlled private corporation, so if you've incorporated yourself, you've run your business, it's 20 years later, your business is doing very well, worth a lot of money, you might want to bring a partner in and sell some of your shares, you might want to sell all of your shares. Your capital gain on that would be the difference between what your shares are worth at the day you incorporated versus what they're worth on the day of your sale. That's the high level of what your capital gain would be, that increase in value. And a great tax break, it's $913,630 per shareholder right now. So each shareholder, each person, I should say, has that amount to exempt. So you can save a lot of tax. So exempting $913,630 can lead to nearly a $400,000 plus offset of taxes that you would otherwise have to pay. So that's a big incentive, and it's also important to think about when you're incorporating who you're adding onto the corporation. So if you have a partner or a significant other, a spouse, and they don't really have much to do with the business, it still may be worthwhile for long-term planning to add them on as a shareholder, or children, for example, so that lifetime capital gain exemption can be maximized. So some potential planning and considerations that you can do around that to, in the long-term planning, when you think about maybe selling your business or selling shares in your business, really reducing the capital gain tax that you would have as a result of that share sale. The other piece for corporations is flexibility. So corporations don't die. They carry on. People die, but corporations can exist forever as long as they've not been wound up or they've not become inactive. So that creates a lot more flexibility in transition planning and organization of the corporation. So it's just something to consider. We won't get into too much of it. The time is running short here, and I want to make sure I've got lots of time for questions. But there's added flexibility as well for investors, how you bring people into the corporation, compensating them or securing them with shares in the corporation is a lot easier to do rather than just traditional loan structures that might only be available to you as a sole proprietor. And then there's more complex things that you can think about, which is, running under one corporation and then having offshoot businesses from that corporation where you can create a subsidiary, which would be another corporation that's wholly owned by your first corporation. So there's a lot more flexibility, a lot more creativity, and a lot more ability to maximize some advantages, liability shields, tax savings, things of that nature. So costs, again, so I just wanted to put, the numbers that are on the screen here are a really wide ranging set of numbers. They don't reflect necessarily my fees, but just what I'm experiencing and what can give you a kind of an idea of what to expect for some costs that you're going to have to incur to set up and maintain your corporation. So there's about a $350 cost that's charged by the government for every corporation that gets registered. If you are going to a lawyer, you don't have to go to a lawyer to incorporate. Anyone can fill out the forms, use a third-party service online and register. My advice would be not to do that. Again, it may not be a problem for you, but if it's not set up correctly and the proper planning has not been made, then you can certainly run run risk of incurring a lot greater expense and liability than you otherwise intended to do by saving a few bucks up front. But those services exist. So I've included a legal cost for actually incorporating. I think it runs the gamut. I've seen as low as 500, might be less than that out there, and I've seen as high as 1,500 for getting a corporation set up. Fees are going to be based on the experience of your lawyer and also the complexity in what you're setting up and the structure of how you're getting things done. And then you've got to order. Well, I always order a minute book for my clients anyways. It's a fancy binder, and it's got some of the resolutions preset in there, and your share certificates that need to be issued. Still have the paper share certificates that get issued when you start up your corporation, and that's about $200. And your accounting fee. So you may have an accounting fee up front for some of the advice that your accountant would have provided in getting your corporation set up. But every year, as part of your corporate income tax returns, you need to have an income statement and balance sheet prepared. So that is some more complex accounting, certainly a lot more than your normal day-to-day individual accounting bill. That could be as low as 500, although that's doubtful. I think 2,500 yearly for your accounting fees is a little bit more of a reasonable estimate. So there's certainly a pretty good size expense there that you might not otherwise have operating as a sole proprietor on your yearly accounting fees. And then you've also got, as you make your structures different in the future, as you're making changes and needing new agreements, there could be additional legal costs involved with that. And then there's the personal time costs of running your corporation. So again, it's a little bit more intensive than your sole proprietor. There's reporting requirements. You've kind of got to be on your toes of the different requirements that are out there for you as a corporation versus sole proprietor. So I think I've stopped right when I wanted to, 10 a.m. So that leaves about 10 minutes for questions.
Thank you. I have a couple for you, and I don't know if anybody else does, but they were from Dana. So one is just when you say minutes need to be kept current when you incorporate, can you elaborate? Is it a monthly expectation? Kind of like what are the minutes you're keeping up to date?
Yeah, so your minute book, why they call it a minute book, I don't know the history on that. I should look it up. But again, that's the story of your corporation. So as far as when you need to do that, yearly for most corporations is fine, but there will be certain events that occur in your corporation that require an update to the minute book. So if there's going to be a director that's resigning and a new director perhaps added, you would probably want to make that resolution and put it in your minute book at the date that occurs. Although I will say that 99% of the businesses I deal with update them yearly for everything that's gone on in the previous year, and then you do your shareholder and director resolutions all at that time. And although it's in breach of the Corporations Act, many people don't update their minute books at all. So I wouldn't encourage that organization in your corporation, but there are rectifying resolutions, and that's also a common occurrence. So no, it's not a monthly or weekly thing that you have to do, but it's just important to know the different major changes that require director's approval for the corporation to take on. So maybe even if it's buying real estate, director's resolution would be required at that time, and then that would have to go in the minute book. So
Okay.
At a high level yearly, but when there's certain events that a corporation is involved in that requires directors or shareholders' consent or approval, that'll be a resolution that needs to go into the minute book.
Okay, great. Thank you. That's a great answer. I have one question. I worked with a client last week who is trying to decide. They have two companies and they want them to be incorporated, but they want to incorporate it under a numbered company and then have these two other companies be whatever their names are. And they're unrelated. One's like an immigration consultant and another one is an IT consulting business. Can they be together under one incorporation and then still have just their trading as names?
So that would require a little bit more information, I think, from a high level perspective, and not really specific advice for them. That person should definitely see a corporate lawyer to look at some structures, but it might be that what they want to do, they could merge, certainly. Doesn't sound like they would necessarily want to, but it may be advantageous for them. Or they could have a new corporation and have a holding company that's a numbered company
Okay.
hold the shares of those two separate corporations. So now
Okay.
you've got the top end of the pyramid, your main corporation, and then below that you'd have the two other corporations as subsidiaries. So now you've got three corporations, three different sets of reporting requirements, three different sets of accounting fees. So it may make sense to do that, but there would be a lot of considerations and factors into why they're motivated to organize it that way, and what
Right.
advantage would be there for them for that.
Would there be a reason to have the two as sole proprietorships and then one that all go into one corporation, or that cannot happen?
So a sole proprietorship to go into a corporation.
That's the wrong terminology. It's actually the doing business as, but yeah, I get where you're going with this. Anyway, my advice to him was to see a lawyer. So
That's good advice. Yep. Maybe an accountant too, because they
exactly.
want to know the motivations for doing it and what tax savings and
Exactly.
there makes financial and business sense.
Exactly. I have a couple more questions for you in the chat box. So the other one is, with regards to flexibility, is it even possible to create an offshoot nonprofit corporation from a corporation?
Yeah, can a corporation have a nonprofit subsidiary? I believe that they can. I would have to, I've not experienced that, or I've not come up with somebody who wanted to do that, but I would have to check. There's a separate act, the Nonprofit Corporations Act. So I would have to refer back to that and see if there's any restrictions on shareholders in that
Okay,
act.
thank
I don't think
you.
that there would be. So I believe that you could run it that way. Again, it's just whether that would make sense is a different question.
Right. Then another question is, Andrea, you've asked about the privacy policy. That's actually going to be dealt with by Pavel. So a little bit later in the presentation, he's going to be talking about the electronic agreements. But last question is, if you decide to incorporate, how many directors do you need for your corporation?
Excellent question. I meant to touch on that and went past it. So thank you for that. So a corporation can have one director. You don't have to have more than that. There are some rules around residency though. So you'd want to just make sure, if you're considering having a director who's a non-resident or is not a non-resident of Canada under the Income Tax Act, there may be some issues with that, especially you'd want to make sure that you're fitting under the small business deductions in the Canadian controlled private corporation, because there's a lot of benefits you could lose, but there's also some requirements under the act that restrict on non-residents, how many non-residents you can have as a director and what proportion of the board they can make up. So excellent question. You could have as little as one. I've not seen more than 10, but I don't believe I'm not sure what the upper restriction is off the top of my head. But the main thing to think about is the residency status.
Right. And I know that some provinces all have different residency requirements. Okay, so other questions, is it possible to just get the book and the bylaws as they are already incorporated?
Yeah, anyone can order that. There's if you've already incorporated and you just want a minute book to kind of keep things up to date. First off, it might sound like that specific person may not have done any resolutions throughout, so they may want to think about a rectifying resolution to get that minute book up to date. But there's a site that I use that you can go and check out. It's called ESC. So the letter E, the letter S, the letter C. You can type in ESC corporate supplies into Google, and you can do an order right there and get them to send you a minute book with some bylaws and share certificates in it, and get that sent directly to you.
Okay, I will put the information in the chat box for them. Thank you very much. One last question I have here. And what are your thoughts on creating a holding company versus just a corporation?
Yeah, so the difference between a holdco versus a corporation, I think, in my opinion, are really just about what you're doing with it.
Okay.
So if you're doing a holdco, most of the time I associate that, or people associate that with real estate. And again, that's very situation specific. So in using the real estate holdco example, and it might be a share holdco that the person's talking about. So there's lots of different holding companies that you could consider, but the most often I deal with is real estate. And what I'll tell people a lot of the time is there could be some financing benefits. So your ability to get financing if you're going in as a partnership. So if you have 6 or 7 different shareholders, you can maximize everybody's borrowing power and perhaps increase the borrowing power of the corporation for mortgageability. But again, there's those reporting requirements, there's accounting requirements that exist for a holdco, regular co. Every corporation has to maintain those. So there's some pros and cons to that. And I'd say if you're only going to do one real estate property, you're not really thinking about 3, 4, 5, 6 properties down the road, that it may not make sense to do it through a holding corporation, that your home insurance, the liability piece might not be so high for those circumstances if you're going to do a residential rental. But if you're going to build that up and try in the future to hold many properties, then certainly a holdco can be a really beneficial vehicle for that.
Okay, good, thank you. That brings us to the end of the questions. Michael, I want to say thank you very much for presenting today. I also want to thank you. Michael is on our board as one of our directors at the BACD. As you may know, we are a not-for-profit serving small business here in the Durham region. We're one of 54 centers. So Michael, thank you so much. I really appreciate it. And I'll make sure that everybody has your contact information so that they can get hold of you directly should they need to.
Thank you very much. Thanks, everybody. Have a great day.
Bye-bye. Good, thank you. So Leon, I'm handing over to you and looking forward to you getting started. So let's find Leon in the chat box, and you should have, I'm going to pin you, and you should be able to share your screen, Leon. And then I'm going to ask you to unmute as well. So give me 1 second. First, remove the pin. Do that again. Okay, good.
I am.
Good morning.
Why am I not seeing my?
What are you not seeing?
Not seeing my presentation. I'm trying to share the screen. I'm not seeing it when I pull it up. Give me a second.
Yeah, no worries. I think you
There.
should still be co-host.
There it is.
There you go. Thank you.
Okay.
So good morning. Thank you, Leon. Leon is a lawyer at Thomas Efraim LLP, and Oshawa has been in law for, I'm just going to say 20 years, but definitely have worked with lots of startups and lots of business as well. So Leon, thank you so much. We're looking forward to your presentation. I'll hand over to you.
Hi, morning, everybody. Teresa tapped me to speak to you all about contracts this morning. Contracts, while she had mentioned service contracts, I find that in presentations like these, narrowing it down to one type of contract actually makes things more difficult to explain because contracts are not specifically legislated entity. Since people have been doing business, they have been entering into contracts of all shapes and sizes, and invariably, what forms a contract has been decided by case law, by determinations by judges. And so that is primarily what guides the formation or the drafting of contracts in Canada, with the exception of Quebec and their civil law regime, which we won't talk about this morning. And the interesting thing is that as we've progressed, legislation comes into determining whether one has a contract or what flaws may exist in a contract as we continue to add new pieces of legislation to regulate different things. For example, at the end of this presentation, I'll briefly delve into the difference between a sales contract and a services contract. And a sales contract generally has to be in compliance with several more pieces of legislation than a services contract, although that's debatable. Nonetheless, there are basic elements to a contract. I've narrowed them down to 5. This is pretty much your first year contract law, 5 basic concepts. You need offer and acceptance, consideration, capacity, consent, and the contract must be for a lawful purpose. Okay. Offer, acceptance, and consideration, they are the top 3 because generally they are the most important. In every valid contract, somebody has to make an offer to do or provide something. Another person has to agree to accept it, and then there has to be some form of consideration exchanged. Capacity, consent, and lawful purpose. In every valid contract, both parties have to have the ability and capacity to understand the terms. So again, this brings us to the concept of having a lawyer review it with you. If you, for example, have used a lawyer to prepare a contract that you are then going to use as a precedent or a template for entering into agreements with other potential customers or purchasers of your goods, you may want to include a clause that says that they've had the opportunity to seek legal counsel, because you want to avoid having them come back later saying, I didn't have the sufficient education, the sufficient knowledge to be able to understand what was being presented in this contract, and therefore I didn't have the capacity to enter into the contract. They have to consent. Again, a simple clause that would include a provision that says they understand and consent to the agreement is definitely proof that they were able to actively agree to whatever is being dealt with in the terms of the contract. Lawful purpose, this is where legislation comes in. So in most instances, we're talking about legislation like the Employment Standards Act, WSIB Act, Sale of Goods Act. This doesn't necessarily mean that you can't contract to do something that is criminally wrong, which obviously you can't. But you can't contract a service provider to do something that's in violation of any of these other acts. So you can't, for example, contract with an electrician to do something that requires a permit and have him agree contractually or her agree contractually not to obtain said permit. There are various types of contracts. One is an express contract. So the terms are transparent. It's like a mortgage with a bank. There's an implied contract. So you go into, the examples there. You go into a restaurant, you're eating dinner, the restaurant expects you to pay the bill. They don't get you to sign something in advance. And then contracts that are signed. That is sort of what we're focusing on. And again, these elements are things you need to be aware of if you're drafting your own contract or if you're looking at a template contract that somebody is giving you. Again, this is sort of repetitive. There has to be intent. Again, if you're providing evidence, I would also suggest that if you're undergoing a negotiation in terms of the preparation of your contract, it'd be best to keep notes in regards to your meetings, what was discussed. If you have drafts that were changed, you've been given a contract, you've decided you don't like something, you've struck it out, make sure you keep a file that shows changes that you requested, and even a file regarding any comments or changes that your counterparty asked for, because again, this all goes to the intent of the parties to enter into a contract. Next, communicating and terminating. So these are, the other part about a contract is because it's common law based, you will typically, if there's a dispute, it will generally be settled by negotiation. And if negotiation is unsuccessful, it'll be resolved by the courts. So these elements that we're discussing right now are elements where your goal should be to try and find certainty with these elements. So in terms of communicating the contract and the means by which the contract can be terminated, you want to see that language being very clear in your agreement. So in terms of communicating the proposed contract, again, a written contract is best, and then evidence that the other person has received the contract, because again, you may have a claim later that you may have pretty much agreed to a contract, performed all the services. For whatever reason, you were anxious to do the work and you didn't sign the contract, or the other party didn't sign the contract. That doesn't necessarily mean you don't have a contract. So things like being able to show how the contract was delivered, even though it wasn't signed, what steps were taken to obtain the signature, all of those things will be evidence that you will want to use to show that you had a contract, and the reason for signing was merely to frustrate or find a way to avoid having to pay or complete the counterparty's responsibilities under the contract. There are a number of reasons why you can terminate a contract. Again, if you have a written contract, I think and I recommend that you list those reasons and be specific so that it's not too broad as to allow any party to walk away simply on the basis that they didn't want to complete the transaction. This is why you'll see in standard contracts various representations regarding warranties and disclaimers regarding warranties and quality of work and that kind of language. That's intended to avoid there being an argument that the type of service that was necessary wasn't provided, it wasn't up to the standard that was expected. And again, not that those are not arguments for claiming that somebody has breached a contract, but it's better to have very clear language as to what those things entail, so that if you're arguing about the contract later, you can point to what is on the document. Until the contract is signed or the work is begun, again, there are cases that dispute this, but generally speaking, you don't have a contract. So one of the things that you can do is revoke prior to signature, cancel an offer that you've made. Bear in mind, if you're the counterparty, if you negotiate or change terms of an unsigned agreement, what you've actually done is created a new agreement. So basically through the negotiation process, if you're changing it, you are actually terminating and creating a new agreement as you're going along. Acceptance. Again, you want clear indication that the other party has accepted. The best way is to have them sign the document. In today's age, things like email communications have been held to be acceptable proof that a contract has been entered into. But the law, while it's a living tree, like any tree, it grows slowly. So to be on the safe side, to stay on the tree theme, you still want to kill some trees and have it on paper. We even have electronic signatures now, which are changing things and are, as expected, the subject of great debate amongst lawyers and the justice system. Consideration. Consideration is obviously one of the key aspects of creating a contract, but consideration can mean many things, and it may not always be the consideration that's contemplated in the agreement. Those of you that have seen or worked with agreements in the past have likely seen on the first page what's commonly referred to as a preamble, whereas, and it gives you a bit of background of the agreement, and then an enacting clause that says, therefore, the parties. That clause will usually include something like, for the consideration contemplated in here and the payment of $1 or $10. Many people think this is silly, and perhaps it is, but it's a convention that was established through several court rulings. And what it does is, in a way, it perfects the agreement by confirming that regardless of anything else that happens outside of the contract, payment for the services, payment for the work rendered, etc., consideration was given by this $1 or $10. One of the interesting things about it is that very infrequently does that money exchange hands. And I don't know that clause is actually something that's relied on very often in court any further. I believe another presenter might be able to speak to that in regards to small claims court matters. But that is a key element to having a contract. That consideration is paid. The capacity, I sort of discussed that briefly, but again, one of the things is they need to be of the age of majority. And if they're not, there has to be a reason why we should consider them able to enter into the contract. And again, it says here for their health and their welfare, that would be the primary reason. Again, somebody who has medical issues is someone that is not considered able to enter into a contract. And sometimes this is, this is important when you've all heard the stories, the furnace people, the gardening people, the asphalt paving people who go door to door, hopefully finding someone who is incapable of entering into a contract. At our firm, we deal with that a lot when it comes to people trying to transact or sell their home and discovering that a registration has been put on by one of these companies. And the argument, generally speaking, is that they did not have capacity due to their age, due to their not being able to understand the agreement, etc. And more often than not, we're able to get that removed. So bear that in mind. Know who the client is that you're dealing with. Consent. So there has to be, again, it has to be very clear that everybody agrees, and it has to be clear that everybody understands. Some of the things that may prevent someone from giving consent are if there's a misrepresentation in the agreement, if it was done by mistake, they thought they were doing one thing, and there would have had to have been an overt act that would have led to the person making the mistake. Undue influence and duress are all common elements that, and in this instance, again, with our aging population, if a caregiver, a relative that is supposed to be a trusted caregiver, tries to convince a homeowner to transfer their property via agreement or whatever, these are the types of issues that would arise in terms of the validity of that agreement. What is a misrepresentation? Misrepresentation involves a false statement of a material fact. It makes consent impossible. There are such things as innocent misrepresentations, but that still won't prevent, or it isn't a defense to the contract being valid. And basically, whether it's fraudulent or not, it should allow the buyer or the offeree to walk away. Mistake. There are common mistakes, and then there are mistakes that are made just by one party who's buying the product. A clerical mistake is one that's made by the clerk or the employee, and the other one is obviously the person just doesn't understand what they're dealing with, and the clerk is aware that the person doesn't understand, or the counterparty is aware that they don't understand. Undue influence and duress, I think I went over that a little bit. And again, when one party uses threats or blackmail or violence, obviously you would not be able to support that contract. Of course, you have to have evidence to prove that that was what was done. Again, we've all heard of aggressive salespeople and that type of thing. The lawful purpose clause. So no contract can violate any provision of the criminal code. Believe it or not, that includes, I don't know if many of you are familiar with the provisions regarding interest rates in the criminal code. So many of you, when you issue an invoice, include a provision that if the obligation isn't paid within a certain amount of time, interest starts to accrue. Be very careful that the interest number you use does not violate the Criminal Interest Rate Act. Any contract found to break the law, and this means any law, can be declared void immediately. Sorry, guys, that's me playing with my mouse. Each contract must have a lawful objective, which I've explained, and certain contracts require special rules or restrictions. So again, we've got the OLG for things like betting, gaming, and gambling, but we also have consumer affairs legislation that deals with contracts for things like buying a car, a gym membership. So there's legislation that affects all of those types of activities. And then there's performance. The most common way to discharge a contract is by performing what you're required to do. This would allow, once done, both parties can just simply say the contract is done, it's discharged, it's of no further force and effect, subject to anything that should continue. So if there was a warranty given regarding a good or a service that was provided, then that continues until such time as it expires. And so when you're creating your contract or looking at your contract, depending on which side you're on, you want to make sure it's clear when certain terms expire. So if you're buying a good, how long do I have to return it if it's defective? How long should it continue to be good for whatever its intended purpose was? Again, if you are a roofer and you're changing a roof, there should be a clear sort of delineation as to, how long the warranty of that roof is, and then what exclusions there are to any warranties that are given. Of course, you can end a contract through mutual agreement. If you do, I suggest that you get that agreement in writing. And then impossibility. This should be, common sense. You can't enter into a contract for something that's impossible to do. And that would be on the ludicrous side of things. There are certain contacts. So, you can't sue. The contract promoter is a good example, I think, of something where you can't promise what the weather is like, or you can't promise that somebody will attend. I understand Justin Bieber recently canceled 2 shows. One would think that a flurry of lawsuits would occur as a result, but they don't, because there is a disclaimer on your ticket that says that the promoter and Mr. Bieber may cancel for whatever reason they believe they're entitled to. Breach of contract. So again, this is common sense. You want to make sure that you are complying with the terms of the contract, but you also want to make sure that the person you've contracted with is as well. This is one of the situations where you want to keep good notes about breaches. You want to provide notice if someone is in breach. You want to let them know that you want to give them a brief cure period. And if you're in breach, this is a tough one, but if you're in breach, sometimes it makes the most sense to own up to it and say, I was unable to complete this but I undertake to get it done within this date, and perhaps make sure it's in writing, ask for an acknowledgement that they received this change. This, by the way, changes your contract, and it could be argued would create a new contract, but that's for us to debate about in court. The various remedies you have. So if you do go to court, you will look for various remedies. One of them is damages. That would be something you receive because you've lost something other than just what you paid. Specific performance, meaning forcing your counterparty to do what they said they were going to do. Injunctions are used when you are trying to enforce a non-disclosure agreement, a license agreement, a franchise agreement, anything where you're trying to protect something and the counterparty is doing something harmful. Privity of contract is an important one to look at, simply because you can't enforce a contract on someone that isn't a party to that contract, which is interesting. If you're doing a contract with a contractor and they're using a subcontractor, then do you or do you not have privity with that subcontractor? What are your rights as it is to that subcontractor? Again, using software in what you're doing, a lot of people have agreements with their SaaS provider or their software provider. Again, you'll see disclaimers from those providers that says they do not have privity with any contract you enter into with somebody that is using your services. And then finally, rescission, the court can simply cancel the contract. So now we're at the end. I wanted to just briefly touch on, contract law and selling goods. In Canada, it is a specific area of contract law. A sale occurs when ownership of a product passes to the buyer. So when you buy a car, the contract is basically done when you've received the car. In order for the sale to be valid, you must get the car in the time that was determined, which today is not happening. And same with the building of houses, but you know, they've gotten away with that for years, and they are difficult to sue. Conditions and warranties for a sales contract. They can have express or implied conditions. You need to make sure that if you're selling something, any conditions there are specifically set out. So again, this is where disclaimers are key. You know, as I note here, the fine print. This may not work for your business. This may not do what you think it will do. And then a contract for services is a contract between two or more parties agreeing to the performance of an express task or service. And it is very similar, although there's nothing that passes along. And sorry, I noticed that there is a reference here. We don't have, we have a statute of frauds, but the UCC doesn't apply here. That is an American legislation. We have consumer legislation typically in Canada, as I mentioned earlier, is managed through Consumer Protection Acts and is a provincial responsibility. And you need to make sure that you are within any laws respecting same when dealing with the providing or the obtaining of services. And finally, me looking at my brand new sign. And I guess we can open it up for questions.
Thank you very much, Leah. And I also want to thank you very much for, you've helped us at BACD, you've helped a lot of our clients, you've been a mentor and a presenter. So thank you so much for everything you've done to help us here at BACD. And there is one question in the chat box. Dana wanted you to elaborate on the interest rate. Do you mean that we need to ensure our specified interest rate is lower than the government's rate?
No. So
Okay,
the criminal rate of interest it's a hard threshold to meet. Although the money lending institutions like payday loans and those guys, they came close. I believe at this point, it would be approximately 60% interest. Wow. On a compounded basis. So, you know, that doesn't mean that there is case law that varies what that criminal rate of interest is. I suggest that when you decide to send an invoice, or if your invoice includes, or your contract includes the provision for interest as a result of late payment, you try and work with industry standards. So I think generally speaking, between 1.5% a month and and up to whatever the credit cards are doing. So, you know, 1.5 to 2.5% a month is sort of within the acceptable range.
Okay, thank you for answering that. Andrea, the privacy policy is being covered by Pavel. So it's he is going on next. So if you can just give us a second, I'm going to make him the co-host. But before then, Pavel, I just made you co-host. We're just finishing up the last questions with Leon. So Dana says, she'll be offering professional services and thinking to organize the work by phases of many contracts. Are there some considerations she should keep in mind with respect to the fee structure? For instance, is it typical to organize the fees for payment after each phase?
Sorry, is it typical to organize the fees after?
Is it typical to organize the fees for payment after each phase?
So yes, but in this instance, what I would be looking at is what we refer to as a master services agreement. And so you'd have a head agreement that contains most of the boilerplate language that you find in your typical agreement. So everything I was talking about today, offer, acceptance, what the consideration is, the terms, and then what you have is sort of a statement of work where you set out the various phases, and then, you know, if it's not certain what the exact consideration is, then there has to be some sort of formula to figure out what you're going to get paid. Because if there's a concept in contracts that a contract is void if it's for a sum uncertain. So if the person doesn't know what they're paying or how much they're going to pay, you don't necessarily have a valid contract. So if that means that, you know, you're using milestones and you say, when we reach milestone 1, I am to be paid $10,000. And when we reach milestone 2, we're not sure how much I'm getting paid. There has to be some sort of formula that sets out how you're going to figure out what you're getting paid. So if it's based on, say, an hourly rate, and you're supposed to report what your hours are, and then that's what you're going to include in your statement of work, right?
Okay. Good. A couple more questions. One, are the slides being shared? Yes. So we will link to the slides through our YouTube video. And then can you explain the contract grace / rescinding period?
The rescinding period. So the period is pretty much a common law, determined at common law, and I think it varies from type of contract to type of contract. So there's no one size fits all. And it's also subject to what would be industry standards.
Okay.
So if you contracted with somebody to do some lawn maintenance or to build your deck, and you reached consensus, you became ad idem, a meeting of the minds on the contract in June, but you never signed it back. You can't, then come back to the contractor in mid-July and say, okay, can you start Monday? Well, I have a contract here that says you're going to start within 3 days of signing the agreement. That's simply,
Okay.
not reasonable. So I think it's more of a reasonableness standard, and the case law will help determine that.
Okay, good. Thank you. One more question I've got is, if you're hiring contractors and employees, can you include in the contract that they cannot say negative things about the company? For example, if they're an ex-employee posting negative comments about the company, is there anything you can do in this situation?
You can include non-disparagement clauses, which their enforceability is is again subject to the circumstances,
Right.
Because other than the contractual rights, this is something that's also managed through legislation. So there's libelous activity and slanderous activity that are different means by which you can approach managing that person. Either way, it's a matter that would be dealt with. If you had to, it would be a matter that dealt with in the courts by way of injunction, or a claim for damages because of the actual behavior. But there are provisions you can include, and that's just one other piece of evidence that you can use if you have to sort of try and enforce or seek damages for the wrongdoings of some other party.
Okay, good. Thank you. Appreciate that. That's the end of the questions. So Leon, thank you very much for presenting today. I know I've got your presentation, so as I said, we'll link to that in the YouTube video comment section, if we'll be in there. And I just want to say thank you again for taking part in this. And I'm going to move over to Pavel next.
My pleasure.
Thank you. Take care. Okay, Pavel, it's your turn. I'm just going to remove the co-host, and now you can share your slides.
Okay, wonderful.
Thank you.
Okay, good morning, everyone. First, a couple of words about myself. I'm a business lawyer. I live in Pickering, and our firm is serving clients in all the GTA and beyond. So that's, I would say, our target area, from all the gold horseshoe, that's say from Hamilton and up to Cortes. So that's our prime area, and that's obviously with in the age of technology. As other professionals, we do work in all Ontario and sometimes beyond. And I practice three things. I do business law, meaning corporate commercial. I provide legal services to various business clients at different stages and different aspects of their business legal needs. Second, I do real estate. So I practice real estate law. It's That's all deals with all types of real estate. It's commercial, residential, sale, purchase, lease, development, so you name it. And the third, I do wills estates. And sometimes it's an interesting fusion of business law, say corporate tax reorganization, combined with, for example, estate planning or business succession planning. So that's what I do. And in addition, I'm also an adjunct professor, adjunct law professor at Osgood Hall Law School, where I teach exactly legal drafting. So I teach my students to draft agreements and some other legal documents. And I've also served as for, I would say, 7 years as an instructor in, we have a great program called Lawyer as a Negotiator. So we also teach our law students not just write vicious letters to, to the other side. We teach them to resolve disputes and close deals through the right approach to negotiation. So that's what I do. And today, sort of pigging back on Michael's presentation and Leon's presentation, that was very, very thorough presentations. And my topic is that's another long and boring, but very important and interesting topic over electronic agreements. And I do appreciate that we have now 11:15, so we've been sitting in this webinar for almost 2 hours now. Oh, sorry, yes. And sorry, that's more than 1 hour. And I understand that my topic in itself, say, when I'm doing this, covering this electronic agreements with my students, that normally takes, like, it's a full 3 hours lecture. So I'm not going to torture. We have 40 participants. I'm not going to torture all of you with this long and detailed discussion, but I will at least, my task today is to raise your awareness of specific issues that people, for example, running businesses through like online business, online sales, or online platform for goods and services. So that's some particularly like Leon covered all important aspects of agreements. And I will just emphasize what you guys need to know about specifically electronic agreements. So something that you do need, oh, yes, I will share my slides. Thanks for asking. I am sharing right now. And Teresa, by the way, that's exactly the same slide deck that we used in our more substantive presentation and doing business in Durham. So how I'm going to use my slides? I'm not going to read everything and anything that you will see here, because in any event we can share it later. But I will emphasize a few important points. So I will try to be as concise as possible. So first of all, specifically about electronic agreements, why we need to care about having electronic agreements and running business through our website, why at all we care about agreements. And the answer is threefold. One is we want to enforce our contractual rights, and we want to enforce our business partners or our customers' contractual obligations. So that's number one. So we care about our agreements. We need to make them valid and enforceable. And I will very briefly will mention specifically in this electronic realm what we need to be mindful about. Second reason why we care about the agreements is that's to isolate our from liabilities. So that's to distance us from the liabilities. And third is also to protect us from possible regulatory liabilities, meaning regulatory meaning something government created. And the good examples could be either this castle compliance, meaning with this anti-spam legislation, for example, and also some privacy issues. Okay, so today we will talk about these issues and specifically 5 things or 5 types of agreements that people running online businesses need to have in their business. I will briefly name them. Okay, so by the way, 1 second. Okay, I'm doing the slideshow. So that's me. First of all, lawyers love disclaimers. My disclaimer, I am not giving legal advice today, okay? And our discussion, our presentation is for educational purpose only. And if you have specific questions, that's, you know where to find me, okay? And I will be happy to specifically discuss your situation and your needs with you, okay? So today we're talking about, first of all, for example, let's imagine a situation, and we'll be talking about, as an example, I will just imagine that we're running, for example, home inspection business. And we have a nice and colorful website. We contracting with our customers through our website. We have some very useful information about properties, about home inspections, about what to watch for when you're buying something, or what to do when you're selling something. So first of all, we need, number one, we need good terms of use, or sometimes let's call it differently. So that's a, yes, let's call it terms of use. And we'll talk more in detail. Next is when you're selling your services. Exactly, that's for selling your services. And there is an interesting element to it, because it's electronic agreements. We all know, so thanks COVID, we know what's the DocuSign, we know how to sign agreements remotely, we know how to do business remotely, and so on. Anyways, we have our electronic agreement, and that's our terms of sale, whatever we're selling, goods, services. So that's our agreement with our customers. Now, and we want these agreements to be valid and enforceable. And I will quickly explain what we mean here. We also need to be mindful about three other, let's call it agreements or elements of our online legal stuff. First, it's our privacy policy, or our sometimes it's called privacy statement, privacy policy, or privacy policy statement. And our customers with whom we're contracting through our online platform need to specifically agree to these elements, same as with the use of cookies. We all know this. And finally, that's anti-spam compliance. So that's 5 elements: terms of use, terms of sale, privacy, cookies, and anti-spam. Okay, 5. Now, with electronic agreements, what we need to be mindful is, unlike or like and unlike hard copy paper agreements, first, electronic agreements can be as valid as a piece of paper, so that's completely fine. However, unlike paper copies, there are some specific requirements, and I'm not going to overload you with all this legal terminology and all these details. However, what you do need to understand and remember, that if you're going to rely on your electronic agreement, so that's something that pops up on the screen, and someone is populating the information and then clicking I agree. For this agreement to be valid, the most important, you need to provide this agreement to your customer in the form in which they can save it for further use. For example, it can be an email with a PDF attachment, or it can be a hyperlink, for example, so that people can download on their computer, save it somewhere for their records. So that's if you are to take something, the most important from today's my presentation, just remember this one thing. If you are doing these electronic agreements, make sure that your customers can save it somewhere, okay? Now, the second interesting element in these electronic agreements, so you can read it afterwards. So that's a lot of this excruciatingly interesting information. So you can read it later, okay? So the second element, extremely important element, is if your business is consumer oriented. So one thing, you are doing a B2B business, business to business, you have assumingly sophisticated commercial partners and your customers, and that's very different story if you are selling your goods and services to consumers. And we know that consumers, it's a household, that's individuals. Say when we're buying our groceries, we're doing this as a consumer, okay? And the government assumes that consumers need a high level of protection much higher than sophisticated business parties. Okay, and that's why there is specific Consumer Protection Act. And again, I'm not overloading you with all this legalese. However, the second highly important thing to take from today's from my presentation is that when you're dealing with consumers, your agreements need to be as detailed as possible. So they need to provide, and that's actually from the legislation, this language, you can see clear, comprehensible, and prominent information disclosure about your products, about your services, about yourself as a business, about taxes, fees, any, we know this expression, hidden fees or fine print. So when you're dealing with consumers, you need to be disclose the information, all related information in a clear, comprehensible and prominent way. Okay, so that's a number one big point of this agreement. Again, if you're interested, you can read it later. And now, specifically, we're talking about, let's talk about this terms of use and the terms of sale of your goods or services. And tell me or raise your hand or show me somehow, have you heard these terms, click wrap or browse wrap? Anyone knows these terms? Okay. So the idea is, and there is actually big body of case law discussing when an electronic agreement is enforceable or not enforceable, particularly how it pops up on the screen. And the idea is that click wrap is that's we've seen different sites. That's somewhere at the bottom. There is like say legal. There is a menu point. You can boom click, or for example, privacy statement. You go there, you click, it opens, and then you read it, and or you don't read it. Typically, people don't read all that stuff. And browse wrap is you also, I believe, everyone have seen, and that's a much better protection for all of us. Browse wrap, it means that before actually using the website or reading the information or opening some windows or menu options on the screen on the website, you actually are required to click, open that, say, our terms and conditions. You actually need to scroll down physically and then take a positive action and click on that, for example, button, I agree, or I've read, I understand, I agree. And you are not allowed to do anything else on the website until and unless you actually open, scroll down, and click on those browse wraps. And why we care about it? Because the business, this website owner or the business running this website, they will have a record of your positive action, actually agreeing and accepting these terms. So that's why we care. So people, if you're running these online platforms or website businesses and so on, first of all, you will need and speak with your IT people how to implement all these agreements, because to have a good agreement, it's one thing, but to implement it in the right way, that's quite another thing. So that's about this click wrap, browse wrap. That's first speak with the lawyer and also speak with an IT guy. Okay, so terms of use of your website, why we need it? That's basically to protect you from all sorts of liabilities. Because say in our example, we are running this home inspection business. We have this website, we populated it, beefed it up with all the useful information for our customers. And then someone is coming and complaining, listen, I read this, maybe I misunderstood, or maybe you somehow, you were not clear what you were saying. So I followed your advice and now I have this water in my basement. So you're liable. So we don't want the situations. So we are protecting ourselves with various statements on us. Okay, so that's terms conditions. That's what we're doing and so on. Disclaimers. Disclaimers of like, we're not guaranteeing anything. We're not warranting anything. We're not providing you with this. Just rely on the information at your own peril. So that's if in one term. So that's the essence of these terms of use. You can use this information at your own peril. Good luck. And second, it also it also regulates the conduct of people on your website. If, for example, you created some interesting intellectual property, some proprietary content, you don't want people stealing your intellectual property. So you definitely including something to that effect, saying that whatever you can use, I mean, you are using it for your own benefit, but not on commercial use and so on. And also say if you're running a website, say we're doing our home inspection business and we have some forum, and then we definitely we want the visitors to our website to be civic, just behave. We don't want some, I would say, heated conversations and so on, or people selling something to others on our platform. So that's, it's not permitted. So that's basically the purpose of this terms of use, what people are permitted and what they're not permitted to do on our website. Okay, now terms of sale, and that's again picking back on Leon's presentation. Leon explained to you all the intricacies of creating a valid agreement. I just wanted to add that first, we now can sign our agreements distantly. We work with all this DocuSign or signable PDF documents. We know all this, right? And we just need to make sure, as I mentioned at the beginning, that however you're signing your documents, make sure that the other side, that your customer is able to save it somewhere for their future reference. Without this, there will be under this Electronic Commerce Act, that will be a big question mark whether you can enforce it. Okay, and again, in your agreement, same as the paper agreement, you are describing all you need to describe your products, your pricing, your this limitation, exclusion of liability, and everything else. So that's the second thing that you need to do. And again, remember that the best thing to do is browse RAF with all these terms of use and terms of condition, and we'll be talking about privacy and everything else. So think how you will implement it. Okay. Okay, now talking about privacy protection, and that's where now, if with these terms of use, terms of sale, we were talking about potential civil liabilities, commercial liabilities. Now we are entering the realm of regulatory liabilities, because now that's jokes aside. Now we're dealing with the Personal Information Protection and Electronic Documents Act. That's a PIPEDA, and the Digital Privacy Act. That's further legislation that added draconian fines and sanctions for breaching, for being non-compliant. So basically, in addition to your terms of use and sale, you need to have if you are collecting your customers' information, and obviously, say to complete an order, you need the name, you need the address, you need the phone, you need the mail, you need something else. Sometimes you need their credit card, sometimes you need their social insurance number, and so on, so on, so on, depending on your business. And once you start collecting this information, you need to make sure that you are compliant with the privacy protection legislation. And the first step, not all, but at least the first step, is to have a properly drafted privacy policy statement on your website. And again, the best is to do it in this browser app format, so that people cannot actually provide the information until and unless they scroll down your statement and at the bottom click I understand, I read, I agree. Boom. Only that you can complete the order. And privacy policy, it's not a rocket science, but it's it needs to have certain elements to that. And you can hire a lawyer, and the lawyers will be happy to earn your fees and draft all this for you. Or you do your own homework, and you can see it, and you will find on the related government sites, you can find some ideas or sort of default templates, what you can consider when drafting these statements. And specifically, that's accountability, so we take it serious. Then purpose of collecting personal information, so we're just telling why we need it. We need it to complete your order. Then make sure that it's a consensual, so our customers consent to us collecting the information. Then we are making all these disclaimers that the idea is, we're saying that we will collect as limited scope of your information as absolutely required. We will use your information as narrowly as absolutely required, and we will disclose your information as narrowly as absolutely necessary. And finally, we will limit retention, meaning we will collect as little as possible, we will use as little as possible, we will disclose as little as possible, and we retain as little as possible. Ideally, we will not retain anything once this transaction is done. Accuracy of information safeguards, meaning again, we're taking this seriously. We have a specific this privacy officer. If you have concerns, let us know. He is our phone line and so on. So that's the idea of this privacy policy statement. But you do need to make sure that before people provide their personal information to do business with you, they agree to these things. Now, another big problem. We all somehow communicate with our customers, with our business partners, with the general public and so on. We want to sell our services. Lawyers want to sell their legal services. Accountants want to sell their accounting services. Say all other businesses want to sell whatever they're selling, and they want to contact people around them using electronic means to make sure people know that we're selling something. And we know that this spam or these unwanted emails, sometimes we're spending a lot of time just sitting and trashing dozens and dozens and dozens and dozens of that spam emails, messages, and so on. So again, the government is taking this very seriously. There is a body of legislation called the Canadian Anti-Spam Legislation. And there might be, again, horribly draconian fines for being non-compliant with this anti-spam legislation. Basically, we need to watch what we're sending and to whom and how. The idea is that almost everything, almost any communication is so-called CEM. So that's it's a commercial electronic message, and that's almost anything and everything. I mean, the scope is very broad, and it's a broad on a purpose. It's basically like no smart guys. So that's I'm sending you newsletter, so I'm sending you some deal information. It's exactly this commercial electronic messages. So the idea is, again, my very condensed suggestion or comment on this is it requires first obtaining consent from people to whom you're sending, and consent, it's a legislative intent. They either express, meaning ask permission, and get a record that yes, people click the buttons, yes, I agree to receive something from you every once in a while. Or it can be implied. Say if it's your already existing business partner, so that's implied, okay, that's fine. We're contracting, so that's we're sending each other what we have to sell, okay? Or for example, implied consent maybe when people post in the public domain their contact information. Say people sometimes have their email, phone number on their Facebook page, or particularly if it's a business. So that's fine, it's implied consent. However, still having that implied consent, it's not a bad thing to actually ask for express consent. And when you're, a good example can be if, again, we're running this online business, we have a website, we sell something, and when we are signing up a new customer, getting the information, so they already clicked on our use of cookies, privacy statement, they already clicked on our terms of use, so now we collect information to create for them this terms of sale document. It's not a bad idea as a part of the registration to ask nicely and politely your customer, would you mind receiving from us our newsletters or some exciting deals? And typically people, like by instinct, they tend to click no. But a smart way to go about it is to give a couple more options. For example, would you like to receive our newsletters and updates once a week? No. Option 2, once a month or quarterly or once a year, or the most exciting or most important, say once a year we will remind you about our existence. or absolutely don't want. So like, sometimes people say, okay, well, say once in a quarter, I don't mind, it's fine. So that will give you this opportunity at least to send something. Okay, and also the second element. So first element is the consent. Okay, and second is absolutely must have is an option to unsubscribe. And you see it in your own, if you open your emails right now, I believe everyone will open your emails, will click on some of these commercial messages, and scrolling down, you will see that fine print unsubscribe. So again, that's on purpose. That's because we are all statutorily required to have this unsubscribe option. Okay, so that's something else to keep in mind. So that's you can read later on. That will be available. Explicit consent, opt out. So that's what they said, that you need to give an option to unsubscribe. Okay, so that's a compliance. Does the castle applies to you? I'm prepared to bet for any sum of money, up to 25 cents, that yes, it does apply to you. It does apply to all of you and to me. Okay. Implied consent, express consent, castle compliance, that's what we have just discussed. You are getting consent, you are keeping record, and you're given this unsubscribe option, again, keeping record. So to summarize what we have discussed, you need 5 essential agreements or documents to help protect you. So that's basically your CYA online commerce document kit, terms of use of your website, terms of sale, whatever you're selling. So that's basically an agreement that Leon covered before me. So that's I mean, that's the same idea. No matter you have it on paper or you have this electronic form, just the electronic agreements add another layer of requirements. It's say DocuSign remotely signed with a keeping record of signing this, and being able to retain for the reference so that someone can save the document on their computer. 3 is a privacy statement. And we have already discussed that the best way is to do this browser app so that people cannot contract with you and cannot use your website unless and until they actually open the document, scroll it down, and then take positive action to click that button. I read, I understand, I agree. Okay. Castle compliance, make sure you have consent to send something, and always give an option to unsubscribe. And also there are some other requirements that you can read when you have a couple of minutes. And cookies, same idea. You're just same idea as a privacy policy statement. I am providing this some information for you, so you can read it in a little bit more detail. Okay. So questions?
I don't see any questions from anybody here. I don't know if anybody does have any questions.
Leon, please ask me a question.
I think it was so much information to check, to go
let's
through.
think. Let's think. You know,
I'm going to remove the pin. And Olga, I'm going to make you co-host while we wait.
Okay, people. Anyways, if you have questions, you know where to find me. I will be happy to speak about any.
Pavel, I have a question that you didn't touch on. This is something that a lot of business people do as a DIY project. They look at other people's websites and sort of duplicate. In your experience, is there a lot of issues that arise in copyright and you know, from people? Is this something that they should really be careful with, or?
We know that one thing is our rights on paper, or our rights protected, legislative rights or common law rights. The other thing is to enforce that, and whether it's worth enforcing. Yes, definitely. I've seen, and I believe that many of us, and probably Leon, you have seen that as well. We do see sometimes situations with violated copyrights. when people use someone else intellectual property creation, say a text, a picture, or it can be whatever, and anything, and using it for their own purposes. For example, I had a client who actually, I can think now about at least 2 clients complaining to me. One business, they're doing some very custom metal fabrications for fences, for gates, and for some other construction elements. And somehow they, by chance, discovered their own sort of samples or pictures of their work on their competitor's website. Phenomenal. And we had a discussion, and a similar situation happened. I have a printing business client. Also, they found a competitor of them posting some examples of their product, and that's definitely it's a still intellectual property. But the question is how much money we are going to spend and have available to fight and defend our rights, say our breached rights. So that's another big question. Say if someone has stolen our privacy statement and using on their website, well, not nice, but you at least could have asked me, right? But are we going to spend money on that? And how actually are we affected by that? Are we experiencing any damages of that? So it's definitely it's a good idea. Actually, interesting element is people sometimes asking, to protect my copyright, do I need to put that little fancy C in a circle? And we know that, believe it or not, we don't, because that's by it's very nature. Whatever we created belongs to us as a copyright. So we, yes, obviously, sometimes people put that C in a circle, like a particular year, and copyright, and whose copyright it is. But if we created, say, if we created some unique music or text or picture or whatever we can create, if we're creative, then it's ours. And again, as I said, how much time, life, money, and everything else we're going to spend on enforcing or prosecuting this say copyright breach. So that's a different, and that's
Yes.
maybe Olga will cover that.
Yes, I think this is a beautiful segue into our next presenter. Thank you very much, Pavel. Appreciate it. And now
pleasure.
moving on, just because time is of the essence, moving on to Olga
Right.
Leyenson from Gobin and Leyenson LLP. Olga, thank you so much. Olga is also a referral partner at BACD, as is Pavel and Leon. So these are our preferred partners for you to go to for this advice that you may need for your own business. So there is a reason why we have specialists in these places, and that we go to them for legal advice, because it's the cost of having to enforce your rights or what you think you own is far outweighs the cost of paying to get those agreements done properly in the first place. So thank you, Olga. I'm leaving it open to you.
Absolutely. Thank you, Teresa, for having me. Good morning, everybody. It's been a pleasure listening to all of the presenters earlier today. I'm going to go through the small claims court process. Just keep in mind that every legal proceeding is on an individual basis, and we're not going to dive into the various legal causes of actions or legal defenses. If you have a particular legal matter, I invite you to contact any of the presenters or my office to discuss it further. With respect to the small claims court, it is a division of the Superior Court of Justice. It is a specialized court in that it hears matters up to a particular monetary amount. As of January 1st of 2020, the monetary authority of the small claims court was increased from $25,000 to $35,000. Now that $35,000 does not include your costs, disbursements, and interest, which I will address today as well. Now, small claims court has legal jurisdiction to hear a variety of cases. It could be a breach of contract, it could be a personal injury, negligence, even employment law, a breach of trust, for example, between contractors or homeowners and subcontractors, even libel and slander, defamation cases, and various tort claims, so long as the amount that you're seeking is $35,000 or less. What small claims court does not have jurisdiction to hear is injunctive relief, and that is an order requiring someone to do something or refrain from doing something. There's a small exception to that injunctive relief as it pertains to return of personal property. So if, for example, I was your employee, and upon termination, I took a business laptop home with me, thinking that it was mine or claiming that it was mine, you could advance a civil action in small claims court seeking the return of that laptop as personal property of the business. Again, the value of that personal property cannot exceed the monetary jurisdiction of the small claims court. Another type of claims that small claims court does not have jurisdiction to hear is declaratory relief. In other words, asking the judge in small claims court to make a declaration that you're entitled to a particular right without seeking any amounts of damages. Quite often we see these type of cases where, let's say, a business suffers a loss, perhaps due to the storm Durham region recently experienced, and the insurance company denies coverage for one reason or another. And then the business is looking for a declaration that the insurance policy was in fact valid at the time that the business sustained this loss. So that type of a claim or that type of a relief would have to proceed to the superior court, not small claims. Whatever the nature of your case or potential defense, if you're the one that's being sued, is, I strongly encourage everyone to obtain legal advice prior to proceeding with litigation or prior to responding to litigation. Obtaining legal advice doesn't necessarily mean you're going to hire that lawyer or that paralegal, but the idea behind that is that you want to be informed as to your rights and your options before you take any steps to minimize particular, damage that you may cause to that litigation process. Well, let's talk about the litigation process briefly. This usual process in small claims court involves pleadings, a settlement conference, and a trial. And I say usual because there are some additional steps that you may encounter, such as motions, default judgments, and so forth, which makes the process a little bit more complex, but nevertheless, we can deal with that. The usual process would start with a plaintiff's claim, and that is an actual document that a party who commences the legal process prepares, issues with the court, and serves on the proposed defendant. This is where you, as the plaintiff, will provide details and the reasons why you believe the defendant should pay you X amount of dollars. This is also the document where you would outline the legal grounds why the defendant should pay you X amount of dollars. So for example, we've talked a lot today about contracts, and a breach of contract is probably one of the most common type of cases that small claims court hears. And if it's a breach of contract claim, you would outline the fact that there was a contract, the parties entered into the contract, what the nature of the contract was, and how the defendant breached that contract and how you suffered as a result of that breach. Now, keep in mind that plaintiff's claims are subject to limitation periods. That is the deadline by which a claim should be issued. Most type of actions are subject to a 2-year limitation period, meaning you have up to 2 years from the time that the reason why you want to sue somebody occurred, or 2 years from the time you discovered the reason why you want to sue somebody. And I say most type of actions because in certain cases, the limitation period could be reduced down to 1 year, for example. Property damage claims against insurance companies most often have a 1-year limitation period as prescribed within your insurance policy contract. Now, in addition to statutory limitation periods, parties to small claims court proceedings should be aware of procedural deadlines. The procedural deadlines are described and prescribed within the rules for the small claims court. Once the claim is issued, the plaintiff will have up to 6 months to serve the claim on the defendant. And you may think, well, 6 months is a lot of time. Of course, I'm going to make that deadline, but that's only if you know where the defendant is located or where to serve that claim. You might need that 6-month period to locate the defendant. Now, from the defendant's perspective, if you're being sued, or as a plaintiff, this is what you can expect from a defendant. The defendant has to respond to the allegations that you present in your plaintiff's claim. They do so by preparing their defense. Now, if you notice, the plaintiff's claim process is that you prepare it, you issue it with the court, and you serve it on the defendant. The defense process is slightly different. We prepare the defense, we serve it on the plaintiff, and only then do we file it with the court together with proof of service. Similar to a plaintiff's claim, the defense will include any supporting documents. It will include your story, why you as a defendant believe that you do not owe any amounts to the plaintiff. Or perhaps you admit to owing some, but not all amounts, and this is your opportunity to outline that as well. Together with those reasons, with your theory of the story, you will provide any legal defenses of why amounts are not owed to the plaintiff. Perhaps
Edwina and Roberts.
Perhaps the plaintiff has missed the statutory limitation period of 2 years and no longer is able to bring that action. In addition to the legal defenses, you should also be aware of procedural deadlines. When you receive a plaintiff's claim, when it is served on you, as a defendant, you only have 20 calendar days to respond. And we often are consulted by clients where they miss that procedural deadline. And it's very important not to avoid service, not to, stick your head in the sand like an ostrich trying to pretend that you're not being sued. Be proactive. The lawsuit is not going to go away just because you choose not to respond to it. If you miss that deadline, you may be subject to default judgment being obtained against you. And that would require additional steps to remove that default judgment, which would then potentially result in additional legal fees. So if you are served with a claim, respond to it or obtain legal advice as quickly as possible. Time is of the essence. Once the plaintiff's claim has been issued and served, and once the defense has been served and filed, the parties will have to participate in a mandatory step called a settlement conference. Many years ago, and I'm probably dating myself, this step was called a pretrial conference. The idea behind the settlement conference is to allow parties to openly discuss all the issues. The court itself will schedule a date and time. And as a result of COVID-19, settlement conferences are now being scheduled virtually, usually by Zoom. The parties can request an in-person hearing, and they would have to provide reasons for such a request. So because the settlement conference is designed to provide the opportunity to discuss the issues and potentially, as the name would suggest, provide the parties with an opportunity to settle their differences before proceeding to trial, the rules of the small claims court require the parties to exchange documents. If you have not provided your supporting documents with your claim, this is your opportunity to do so. So disclosure of documents must take place at least 14 days prior to the settlement conference. You have to deliver those documents to the opposing party and file a copy with the court together with a proof of service. In addition to disclosing the documents that you intend on relying upon at trial, each party is required to prepare, serve, and file with the court a document titled a list of proposed witnesses. Again, this must be done at least 14 days prior to the settlement conference. The list of proposed witnesses is, as the name suggests, is simply a list of the people that you intend on calling at trial as witnesses for your case. Now, you may have no witnesses at all, or you may have 15 witnesses. Whoever you choose to call at trial must be listed. As a side note, witnesses don't actually belong to either party. We refer to them as my witnesses or your witnesses to simply indicate who is calling those witnesses, who is bringing them to trial. But witnesses are considered neutral because their job is to appear at trial and under oath to tell the truth and nothing but the truth, whether that truth benefits you or not. Now, if the case settles at the settlement conference, great, it doesn't go any further than that. And keep in mind, the parties can resolve their differences at any time prior to trial. But if for some reason a resolution cannot be reached, then the case proceeds to trial. Now, how long the trial will take is going to be subject to how complex the case might be. It will be subject to a number of witnesses. The shortest trial I have ever seen in my experience was half a day. And the longest trial that I had personally conducted lasted for 10 days. And that might sound excessive considering it is a small claims court, but keep in mind that it's not a matter of where the trial is heard, it's a matter of complexity and obviously the volume of evidence, documents, and witnesses that each party presents. You want to summon your witnesses well in advance of your trial once you become aware of the date and the time. Recently, we've been advised that trials in small claims court are returning to an in-person hearing unless the parties agree and request to conduct those trials by Zoom. You want to prepare your evidence well in advance. You want to make sure you have sufficient copies for the judge, the witness, yourself, and the opposing party. If you have not yet disclosed a particular document, you can do so 30 days prior to trial. Keep in mind that there's no such thing as a trial by ambush, so there's no surprises, or at least there shouldn't be. Now, this is just a brief overview of the actual small claims court process. And you may ask, well, what amounts can I possibly request in small claims court? You may have heard a term called damages. In the legal world, we don't utilize this term to describe something that was physically damaged. We utilize damages to describe the actual amounts that the plaintiff is seeking from the defendant. We can also see costs, which is a partial reimbursement of your legal expenses. We can seek disbursements, which is out-of-pocket expenses, your court filing fees, as well as your interest before the judgment is rendered and post-judgment. Whether that interest is contractual, which will be outlined in the contract, or whether or not it will be in accordance with the Courts of Justice Act. Now, once you obtain the judgment, there's also consideration how you're going to collect your money. Large companies that are sued as defendants usually cut a check after judgment is granted. But that is not always the case with individual defendants or perhaps smaller businesses. So you need to consider whether or not you're going to be able to collect the amount that the court awards you. And you can do so by garnishing wages of an individual. You can do so by garnishing a bank account of the individual or the business. You can do so by registering and enforcing a writ of seizure and sale of land, or a writ of seizure and sale of personal property. But if you have no information whatsoever in order to enforce the judgment, you would have to conduct yet another hearing before the court, a debtor examination. The debtor examination will allow you, as the creditor, to bring that debtor into court and obtain details of their assets. During the debtor examination, you can ask such questions as to where they bank, whether or not they have any assets, equipment, vehicle, property, and so forth, against which you can then enforce judgment. I think the most common question that we hear is, should I sue somebody? And I think the best answer that any lawyer or paralegal can provide is, it depends. It depends on the amount that you're pursuing, whether or not the litigation process is worth the cost of litigation. It depends on the likelihood of collecting that amount if you succeed. You may unfortunately find yourself pursuing legal action against a defendant who has no assets, no jobs, and the chances of collecting that amount is slim to none. What about a potential defendant who disappears? And you're going to have to spend time, money, and effort trying to locate that defendant just to serve them with your plaintiff's claim. Do you need legal representation for your case? And if so, what would that legal representation cost you in comparison to the amount that you're pursuing? So it has to make economical sense. In addition, there are going to be some disbursements that you're going to pay as a plaintiff, regardless whether you hire legal representation. Today, the cost of issuing the plaintiff's claim in small claims court will cost you $102. The cost of requesting a trial is $290. So without even considering the cost of legal representation or any other factors, we can see right away that you're spending about $400 out of pocket just on disbursements alone. And that brings me to the next question. Do I need legal representation? Excuse me. And again, my answer is, well, it depends. How complex is your matter? What is the amount that you're seeking? Again, what's the likelihood of collecting? And whether or not you, as a business owner, have the time, the energy to pursue legal action, or is it better to pay a legal representative to do so on your behalf so you can concentrate on your business? Now, hiring a legal representative does not mean that you get to completely step away from the process. You're going to be involved, but You don't need to speak to the opposing party or the opposing representation. You don't need to draft the legal documents. You don't have to serve them. You don't have to file them. Your legal representative will usually do that for you. Many legal representatives, paralegals, and lawyers alike often offer limited scope services. In other words, you don't need to hire them from start to finish. If you locate a paralegal or a lawyer who offers a limited scope services, you may be able to hire them for a particular step in the proceeding, maybe only to provide you with a legal opinion, maybe only to conduct the necessary legal research and prepare your claim or your defense, maybe only to conduct that trial. Whatever the case may be, you may wish to discuss that with the intended legal representative. So how much does it cost to pursue a claim or defend a claim in small claims court? Again, the answer is, well, it depends. We know that we have certain disbursements that each party is going to have to pay. Plaintiff's claim, filing a defense will cost you $73, for example. Summoning a witness to trial, just to issue that summons, the court will charge you $31 for each summons. And then you have to consider the legal fees. Now, there's no prescribed amount that lawyers and paralegals charge for legal representation. So discuss that well in advance of hiring a lawyer or paralegal. It could be an hourly based fee. It could be a fixed fee per individual stage in the process. In my experience, the average cost of legal fees for a small claims court is anywhere from $2,500 to $6,000. Could be more. If you decide to proceed as a self-represented party, which you absolutely have the right to do so, again, consider the cost of self-representation. While you may not be paying legal fees, but the time away from your business may cost you money. It may also cost you money with the results that you obtain due to lack of knowledge of legal issues or legal procedures, requiring you perhaps to duplicate certain steps, or perhaps you are not asking for amounts of money that you're entitled to because you simply don't know that you are entitled to. Whatever the question or the issue might be, again, I can't stress enough that obtaining a legal opinion prior to commencing or responding is imperative, even if you decide not to retain the services of a lawyer or paralegal. So in a nutshell, and I know we're running behind schedule, but that is my information for you today. And I invite you to contact our office should you have any questions arising from the information you hear today. My office is located in Oshawa. We do provide services across Ontario. Outside of civil litigation in general, which includes small claims court, my office does offer services in criminal defense. My partner is a lawyer, and we have a number of paralegal associates. And in light of the business members of BACD, we can also offer services when it comes to land planning issues and various provincial offenses that often businesses face, perhaps, breaching a building code or breaching Occupational Health and Safety Act. And subject to time allowance, Teresa, I welcome any questions from our members.
Thank you very much. There is one question we had, and more than a point. So I think it was around when someone was being summoned. So if the person is out at the cottage or out of the country or hasn't received the letter and they don't know they're being sued, what happens?
So the usual process is this. So let's say I'm going to use Teresa as an example here. Let's say Teresa sues me, and as you suggested, I'm at a cottage. She's going to come knocking at my door, and somehow she leaves this lawsuit at my home. Now, the rules of the small claims court outline the different ways that a plaintiff's claim, the lawsuit, can be served. if it was served, and let's assume for a minute in accordance with the rules, but I'm not aware of it, Teresa will ultimately note me in default and obtain what's called a default judgment. Based on that default judgment, she will try to collect her money either through garnishment or any other enforcement procedures. Once I become aware, perhaps she garnishes my bank account and I will notice that the money is missing. I'm going to try to find out why the bank sent money to Teresa. They're going to tell me, well, because we have an enforcement process. And at that point in time, I'm going to become aware of the lawsuit. The process for me to remove that default judgment is to bring a motion before the court. The motion is to set aside the default judgment, to terminate all the garnishments if they have been commenced. In order for me to be successful, I have to explain to the court, A, why I did not become aware of the lawsuit. So in other words, I have to tell them the story, and that's usually done in an affidavit, a sworn statement. And the fact that I actually have a defense against Teresa's allegation against me. And I brought this motion as quickly as I could once I became aware of the lawsuit.
Okay,
So these type of motions are frequent for a number of reasons, and one of them, as you've suggested, somebody was away, and but as soon as you find out that this lawsuit and this judgment exists, absolutely you have to move quickly.
Excellent. Thank you very much.
My pleasure.
So that brings us to the end of the masterclass. I thank you and our previous presenters for being here today. Very much appreciate it. This information will definitely be added to our YouTube channel. Heidi had one more question. The bank doesn't reach the owner of the bank account before garnishing?
No, they do not. So the process says that, again, I'll come back to Teresa as being the plaintiff. So the process in small claims court will be that once Teresa obtains the necessary documents from the court to garnish my bank account, she's going to serve my bank. And within 5 days of serving the bank, she's going to serve me with that garnishment. But based on your suggestion, I'm not home. I'm at the cottage. So much like I did not become aware of the lawsuit, if that garnishment is somehow delivered to my home and I'm not there, I'm not aware of that. But the bank themselves, they do not notify the account holder that there is a garnishment. In fact, the bank has a duty to act promptly and take as much money out of your account to satisfy that particular garnishment. And if that means all the money in your bank account, then that's what they do.
Wow. Okay. Thank you very much. On that note, I hope everybody was able to get a lot of information from today and have some questions answered. There was a lot of information, and I also ask you to reach out to the lawyers directly and to the law practices that are represented here today. They are experts in their field. They know what they're doing, and as I said earlier, it really does help you in the long run as a business owner to make sure that you have the contracts and services that you need for your business. So again, thank you, everybody. If we can help you at BACD, the Business Advisory Center Durham, reach out to us as well. So have a good afternoon, and this should be on the channel by the end of the day. Take care. Bye-bye.